Good morning, everybody, and welcome. It is Sunday, February 1st, 2026, and this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you so much, everybody, for being here. Thank you for those who are joining us in the chat. Proud Grizzly, Joy W. Can, Lori 1120, Pammy MC. So great to see so many familiar names and faces. To everybody who's watching on Facebook or X, thank you. Thanks for watching. Thanks for checking us out. Please say hello if you can in the chat. We would love to hear from you. And to everybody who's new, welcome. I think you're really going to enjoy this. If this is your first Sunday Fun Day, I'm going to explain what it is in just a second. But I think you're really in for a treat because we've got a lot of great questions this week and a lot of interesting topics to get into, and we're going all over the map. So first, let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years before I left to go into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the idea of presenting to you both sides of the courtroom, and we hope that we do that. And then we started this show, Sunday Fun Day, with the idea of, hey, people have questions. What's the best way to answer them? So if you leave us a voice message, and I'll tell you how to do that, I will answer them live every Sunday at this same time, usually, I should say, when we're able to do it. And I answer as many questions as I possibly can. I know sometimes it may be frustrating because you've called in and I didn't get to your question. Sometimes that has to do with audio problems and you know that we weren't able to hear your message, so I apologize for that, but I answer as many of them as I possibly can. But if we have too many and there's kind of duplicates, I hope to touch on every subject, but I really appreciate you guys calling in. The only stuff that I try not to touch is anything that might be political, because we try to keep this a politics free zone. It's just about true crime or the law. But I appreciate you guys. You've done it again. Really, really great questions this week. So thank you. Thank you so much. As always, please stay to the very end. We do have some announcements for you, and I don't want you to miss out on them. Some fun stuff I want to share with you. But first, let me thank Heather Cooper Smith so much for the super sticker. Thank you so much, Heather, for kicking us off this morning. Appreciate your generosity. And to Allie Foley for gifting the membership. Appreciate you as well. Always love those gifted memberships. Because we try very hard to put together a great membership program here that gives you lots of added benefits and quality content. True crime in a minute. Thank you so much. Turn membership receiving on. Great idea. Please remember to do that. All right. Take a deep breath. You've made it. It's another Sunday. It's going to be okay. Everything's going to work out. Hit that like button if you haven't already. Subscribe if you haven't already. Share this with anybody that you think might enjoy it. But let's get to our first question this week. Who is kicking us off?
Hey, Josh. Good afternoon. It's Johnny Knoxville, a.k.a. Christopher, phoning in from Chapel Hill, North Carolina, where we're eagerly waiting for Snowmageddon, which I don't think is going to be as bad as they say, thankfully. My question for you is, and I hope that this doesn't cross professional guidelines for you, but I could see it possibly being an issue. If you could take any high-profile case or prosecution where the prosecution lost, let's say OJ, Casey Anthony, any case, high-profile case that everybody is well aware of, if you could change something or do something differently than what the prosecutors did, whether it's, call a witness that we didn't see or hear about, an OJ, it was the woman who saw OJ speeding away from the crime scene and recalled his license plate. Let's just say Jill Shively, I believe was her name. But if you could take any of these cases and you could change something that might garner a different result or let's say a successful prosecution, which case would it be and what would you change about it? Again, I'm hoping this doesn't cross professional guidelines for you, but if it does, I'll understand. All right. Have a good one. Thank you.
Chris, Johnny Knoxville, one of my dudes, starting us off with one of my dudes from Chapel Hill, North Carolina. Let's put you on the map. Thank you so much, my friend, for all your support. Always great to hear from you and a great question. If I could change one thing about I'm guessing, a case that we're all familiar with, and a case where the prosecution lost, where I feel like they shouldn't have lost, what would I have done differently as a prosecutor? I love that. You mentioned OJ. I can't think of a better example. I mean, I was trying to think of, hey, is there anything else out there? Nothing, I think, stands for the prospect of a blown prosecution more than the OJ Simpson case. Certainly, having been a prosecutor here in Los Angeles, that case still haunts the halls of the DA's office. I mean, they still talk about not repeating the same types of mistakes. There she is. Poor Marcia, watching her career fall apart and slowly before her eyes. There is no other case that haunts the DA's office as much as this case does. And they still talk about it, not repeating those same mistakes. What could they have done differently? How could we perform an autopsy on that case? How do we reverse engineer all the mistakes that were made? I went to a whole training when I was in the DA's office, done by one of the prosecutors on this case, Bill Hodgman. He doesn't get as much attention as Chris and Marcia do, but he talks about what they did, why they made certain decisions, and what they would have done differently. So you mentioned something, I think that's a great example, Chris, which is the Jill Shively. She was a witness that had seen, this is what she witnessed. Soon after when they believe the murders took place on Bundy, she nearly gets into an accident with OJ in his Bronco on his way back to Rockingham. And she says that she locked eyes with him, knew exactly who it was, and he was in this panic state and driving quickly from the area of Bundy to the area of Rockingham. Pretty important witness, right? Helps you kind of place the suspect at the time of the crime, leaving in a panic, all of that stuff. Usually a witness that you would call probably within your first few witnesses. They did not call her because one of the problems they were dealing with on this case was the amount of media. It wasn't just attention. It was absolute hysteria. And they were getting to a lot of the witnesses ahead of time and offering these people money to do interviews. And she was one of them. I think she went on A Current Affair or something like that. And the DA's office felt anybody who received money to talk about this, they can't put on the stand, which is usually a pretty good standard to have. You don't want to appear as though you've got witnesses who've got some sort of financial interest in the outcome of their testimony. This case, though, was different, and I think they should have put her on the stand. But I'll be honest with you, that's not what I feel is the biggest mistake. In fact, I don't feel that it was anything, even though I think the DNA was the way they handled that, the way they handled the defense's presentation of the forensics, all of that was done poorly. But if you ask me, what would I change that I think could have the biggest impact on this case? It's two things that took place before even witness number one was sworn in. And that is, number one, I think they should have papered the judge. Judge Ito was not the right judge for this. He made many mistakes on this case and allowed the defense to get away with far too much. Did they know that going in? I don't think so. But if you're asking me in hindsight, I think getting a different judge on this case would have had a remarkably different outcome. And two, jury selection. They blew it on jury selection, which oftentimes is the problem when a prosecution goes sideways, is they just didn't handle jury selection properly. And I think that is what they were left with. I think they lost this case before opening statements because of the jurors that they picked to be on this case, because those jurors, even years later, hearing some of them do interviews, it was apparent that they had a bias, had an agenda going into this thing. That is kind of my personal belief. I feel, we could talk about this all day long and probably have a healthy debate about it. But if I had to go back and do things all over again, I think making those two big changes would have maybe even turned it around, that you would have had a conviction. Who knows? But we don't. We live in a world where he is not a convicted murderer. And I guess that is still a unsolved case to many people's view. Yeah, probably not trying on the gloves was a problem too. All right. Thank you so much, Chris, Johnny Knoxville from Chapel Hill, for kicking us off. Bonnie Teat, thank you so much for the super chat. Happy Sunday fun day. Right back at you. Mystic Puppy. Love that. Just become a member, everybody. Golf clap for Mystic Puppy. Welcome aboard. I love that. What is that? An emoji avatar. It really does look like a Mystic Puppy. So appreciate you. Roy, there you are, my friend. Thank you so much for being here. All your support, gifted 5 memberships. Appreciate that. Congrats to everybody who receives one of those. And Ann Potter, thank you so much for the super chat. You guys are fantastic this morning. I love it. Cody in Tennessee, there you are. Thank you so much for gifting the membership. Appreciate you all and your generosity for keeping this channel running. Best Nancy, thank you, Best Nancy, for all your support. All right. Oh, Hidden in the Shadows. Thank you for gifting a membership. You guys are fantastic. I love this. Annalie Finch. For coffee donation for our fantastic mods. We do have the best mods in the business, and they need to stay awake though, so they need some coffee. Good morning, my favorite couple, the Ritters, great mods. Thank you, Debbie, for being a member for 1 month. Happy 1 month anniversary. Oh, Dr. Patrice Berry is here. Hello, Dr. Patrice. Happy Sunday from Virginia. Hope everyone is staying safe and warm. Speaking of which, she gives me a good opportunity to say that I just did a wonderful live stream with her yesterday where we talked about the Brendan Banfield case. So as soon as we're done here, go over there, check it out, subscribe. We had a really, really nice chat, and I hope you guys enjoy it. I know I thoroughly did. And I forgot to say, it's February 1st. It's the beginning of a new month. And this is a big month for us. It's a very special month for Courtroom Confidential because a couple of things are going to happen this month. So we're teasing you right now with a big celebration we're going to have. First, it will be our 2-year anniversary of Courtroom Confidential. It takes place in February. That is going to coincide with our 100th episode of the Weekly Roundup, which is the show we started out with, and the show that we release as a podcast every single week. So fun stuff coming up, giveaways, prizes, I'm sure, all in the works. February is a good month for Courtroom Confidential. And thank you, Dr. Patrice Berry, for staying juiced as always. All right, Annie Foley, may February be the reset so many of us need. Very true. Thank you for that. And Bree Roz just became a member, everybody. All right. Can I move on? Moving on. Okay. Here we go.
Hi, Josh. I'm Natalie Christina, and I live in Annandale, Virginia. I'm a big fan of your channel, as well as Gisela K's. I was the grizzly in the white blouse in the courtroom on Thursday in the au pair affair trial that she gave a shout out to. In my opinion, the defense lacked the pace to land anything significant and aren't very prepared. An example of this was when the power went out on the defense attorney's laptop. He then used the private investigator's laptop, which brings me to my question. Why was the private investigator the defense hired, Mr. Harry Litsky, allowed to be in the courtroom the whole time, especially days prior to his testimony? Also, what really surprised me is that he practically guided the defense attorney throughout his testimony on Friday, telling the defense attorney where to scroll to in the evidence. It was almost as if the private investigator was part of the defense team and a witness. Please help me understand why he's able to do that. Thank you so much. By the way, I'm really glad Judge A admonished the defense. It's almost as though they're milking their hourly rate. They're so painfully slow and unorganized. Anyway, hoping and praying for justice for the victims in this case. Stay safe and warm, everyone. I'll be tuning in as we'll be snowed in. Take care.
Appreciate you, Natalie. Thank you for that inside scoop about what it's like inside of the courtroom. Let's put you on the map. Annandale, Virginia, right in the area of where that trial is taking place. Before I'm going to answer this question, it's a great question, but I've got a question back to you guys because we've talked a lot about kind of the ineptitude, the clumsiness, the shuckery of the defense attorney in this case. And I'm wondering, do you fear that some of the jurors might feel bad for Banfield? Feeling like, God, the guy can't even, this attorney's just blowing this whole thing. And might it have the effect of some people giving him more credit than the evidence deserves on his part, more benefit of the doubt than he deserves according to the law, because this lawyer just seems to be kind of stumbling his way through this case as if it was his first trial ever, which I don't think it was. Other thing I'll add is I don't think he's purposefully stalling for the hourly. I doubt he's being paid hourly. I'm sure he got some chunk of money at the beginning, and you would think he'd be trying to get himself through this thing quickly, but no. Maybe he's got nothing else to do. Maybe he doesn't want to go home. I don't know. But your question is, why is the private investigator allowed in the courtroom? What I love about questions like this is stuff I take for granted and never think about and would never even think to answer until you asked it. So usually in trials, the judge will either just give the order, or upon the request of the parties, he'll give an order, he or she, which is called a motion to exclude, meaning anybody who's a potential witness in this case needs to get out of the courtroom. And they're certainly ordered to get out until they give their testimony. Sometimes it's all through the trial. Sometimes after they testify, a judge might allow them to sit in again. That serves a couple of purposes. One, it makes sure that there's not some sort of inappropriate influence upon their testimony because they're just simply responding to what somebody else said or mimicking what somebody else said, something that's not truly a memory of theirs, but they heard somebody else testify to it, so they think that must have happened. The other thing it does is it gives it's good for the optics of the jurors. They certainly don't want to see somebody who's been watching the whole thing then all of a sudden take the stand. That may make them question the veracity of that witness. But what will often happen is that the judge will allow the prosecution to designate the lead detective as their investigating officer and remain in court. I would do that all the time. I would have my detective sitting right next to me because he or she knows the case probably better than I do. They've been living with it longer and they can help me with stuff. They can say, hey, by the way, I interviewed that witness and X, Y, and Z, or, hey, we have a photo of this issue that we're talking about right now. And they kind of help us dig through paper and everything else. And the defense is allowed to do the same thing. They're allowed to designate their private investigator as a investigating officer and allow them to remain in court at all times. And that makes sense too, when you think about, we're not as concerned about the detectives having their testimony influence because it's already been memorialized in some sort of report somewhere. So it's not like they can really pivot all that much. I imagine that's what took place here. I don't know firsthand if that's the orders that the judge made in this case, but that is probably what took place. And sounds like this attorney can take all the help he can get. So appreciate that insight. And thank you, Natalie, for being in court. Maybe we'll see you there on Verdict Watch, taking place all next week on Courtroom Confidential Live Trials. Shelly Flory, thank you for the super sticker. So nice of you. Good to see you. Appreciate the support. Therapist, thank you for the super chat. I appreciate this. Says 5-hour opening, 8-hour closing. Who actually sets time limits on openings and closings in criminal trials? Is that pre-negotiated, set by the judge, or requested by parties? I can't with Beth Silverman. The answer is there is no rules on it. It usually is a court rule. The judge will say, sometimes the judge will say, I'm giving you X amount of time. Sometimes the judge will say, I'm letting you take whatever you need, but let's be move with alacrity in our closing arguments. Sometimes the judge will ask the parties, how much time do you need? It really depends on the complexity of the case and the seriousness of the case too. I mean, the last thing you want to do when somebody is looking at the death penalty is turn to the defense and say, you only get half an hour to argue this thing. They're going to appeal that. But I do think sometimes it gets excessive, but I also think sometimes it's the most important part of the trial. And if you're not allowing the attorneys to sum this all up for jurors, then we might have wasted our time for the last couple of weeks if they don't understand how it all fits together. Great question, therapist. Appreciate the super chat. All right. Eroy, thank you for the super chat. Says Betero likes to call it lack of intellectual curiosity. I think that's a great way of putting it. Thank you for that. Walters 132 just became a member, everybody. Welcome aboard, Walters. All right. Jules just gifted a membership. Appreciate you, Jules. And Malibu Table Mabel, congratulations, she says. Thank you so much. Appreciate seeing you this morning. All right, let's keep it rolling here.
Hello, Josh, Tiff, Kaylin. This is Sarah calling from Dublin in Ireland. Good evening to you, your lovely kids, and the rest of the CC family. Love the show. Found you initially through Candace. There you go. I just have a question in relation to the death penalty. I'm in my mid-50s now, and there clearly has been a huge shift in attitude regarding the death penalty. I'm wondering what you think. Do you think perhaps it's lost its, what's the word, power? To me, it now seems as though it's become a bargaining chip. I guess what I'm saying is that the accused is perhaps more likely to make a deal on condition that the death penalty is taken off the table. So the threat of the death penalty, it just doesn't seem to carry any weight from what I can gather, particularly in respect of it as a potential threat. And indeed, from what I can gather, there's a moratorium in place in many states where has not been used and won't be used. Do you foresee a change coming in relation to the death penalty in general? Thank you. I'm very curious on this one. All the very best to everybody. Take care.
Oh, I think I messed up something here. Sarah from Dublin, Ireland. First of all, thank you so much for calling in from Ireland, putting Dublin on the map. I think that's our first caller from actually Dublin. So thank you very much for that. Great to hear from you. And this is a great question. This is a Black Witter says, great question. Good question, Sarah. This is very perceptive, I think, as to kind of the temperature of criminal law, especially here in the United States, as it relates to the death penalty. And it's also bringing up an issue that I think has been long debated and certainly something I'm interested in. And that is, when talking about the death penalty, many times people bring up the idea of, is it really a deterrent? Does it really stop people from committing crimes? Like, if we have this on the books and it's supposed to make certain crimes so heinous that you could be looking at being put to death by the government, are we actually preventing crime from that? Really interesting question, something I think we could debate for hours. I'm certainly not going to solve any of it here in a few moments. I will say this. One, I think there is mixed data on whether or not there is a deterrent element to the death penalty, or quite frankly, any criminal law. I am aware of and have seen how some active gang members are aware of changes in the law and will change their behavior. I'll give you a great example. It used to be on the law that a drive-by shooting made you eligible for the death penalty and eligible for life without parole. If you were in your vehicle and you fired from your vehicle, and what we call a drive-by shooting, there was a loophole in that if the vehicle was stopped and the person was not entirely inside of the vehicle during that drive-by, because it was no longer fit the elements of what a drive-by was. You had gangsters, this is flat out true, who would stop their car and put one foot on the ground and then light up an entire house because they were trying to avoid that allegation for a drive-by. So when people say, well, changes in the law have no effect on criminal behavior, that is just simply not true. But does it deter it? Like, do we have statistical evidence that people will not commit a crime because they know about the exposure? I don't know if I don't know if the data supports that. I will also say that people who are willing to commit murder are not entirely thinking about consequences all that much, usually in the very logical way in which you or I might. I will say, though, that if you're asking about trends, it does seem that as time goes by, more and more states take the death penalty off the books, or they have it in some sort of moratorium. The death penalty has been voted on in California several times, and every single time the voters of California asked to keep it on the books. And yet the governor has essentially made it dysfunctional. He's essentially shut down even death row. So we're in a moratorium that is not entirely voter supported, but is supported by our current political establishment. So I think you're seeing that much more often in many different states, and maybe it will get to the point where they'll just remove it entirely. But for right now, I agree with you that it does seem the most direct effect that we see with it is with this idea of plea negotiation. We're willing to take, prosecutors will say, I'm willing to take the death penalty off the table if you take a plea, but you're going to life without parole. And that does happen quite a bit. These guys get in and they're big, tough murderers. And then they realize they're looking at the death penalty and they're willing to take deals a lot of times. Now, that's not the reason it should be on the books. That's not how we should be using the death penalty, but it does have that effect for sure. Great question, Sarah. I wish we had more time to discuss all of that. So appreciate you asking. Fala, damn it. Fala, damn it. Thank you so much for the super chat. Says, I don't see how Banfield or his attorney seriously thinks that anyone believed a word out of his mouth. He was just ick and ridiculous. Bonkers. Great word. Hi, Josh Tiff. Oops, I missed the rest of it. Hi, Josh Tiff and awesome mods. Love you guys so much. I agree with you. Well, first of all, I think Banfield lives in a fantasy world and probably thinks he did a great job, but I don't think he did himself any favors, though there was probably very little room for favors to be done. Appreciate the super chat. Be kind. It matters. Just became a member. Welcome aboard. Be kind. And I know this person, Kaylin. Thank you for the anonymous gifters to Christine Robinson and to Christine Robinson for the mod coffees. Appreciate you, anonymous, and all your support. All right, let's keep it rolling here. Hold on. Give me 1 second to not lose my place. What did I do? Did I mess this up? No, I did not. Okay, here we go. And now that's a computer glitch because it's just heard me having a hard time.
Hello, my name's Vicky. I'm in Shropshire in the UK. I have a question about the Banfield case. Juliana Magliese took a plea deal, and in Sunday Funday this week, Josh said that she has a Fifth Amendment right to not take the Fifth. And I was wondering if, as she's a Brazilian national, whether she actually has that Fifth Amendment right, because she's not a US citizen. She's been charged in the US, but she's not a US citizen. So does that Fifth Amendment right still count for somebody that will be eventually deported back to their country of origin? Thank you very much. Hopefully you understood my very gobbled question there. Bye-bye.
Vicky, it was not gobbled at all. And in fact, it was another one of those questions that makes me go, God, these people have got it together. This is a very, very smart question. Smartest community on YouTube, if you ask me. Again, something that doesn't get talked about all that much if we hadn't been asked it. But so Vicky from Shropshire, pardon me, let's put I hope I'm saying that right, Shropshire, England on the map. Is asking about in the Banfield case. Juliana Magalhães is not a U.S. citizen, and she is, after she serves whatever prison time she's sentenced to, which may not be all that long, she's going to be deported back to Brazil, and everybody knows that. So Vicky wants to know, well, then why is she taking advantage of the Constitution? Why does she still have a Fifth Amendment right? Which she does. And if I had said that before, I can't remember talking about it, but I was right. The reason for that is in the Constitution, and you have to go back to it. And there's plenty of case law on this, supporting this, but I wanted to actually show you guys the amendments that we're talking about. So this is the Fifth Amendment. What I love about this is that we talk about the Fifth Amendment all day long and all the rights that we have. And it's really just a few sentences long. It's really remarkable how much we've been able to glean and add to and expand upon when it comes to just a few sentences that were put into the law. So this is the Fifth Amendment. I'll read the whole thing. No person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. So that's first of all talking about how you have to have some sort of probable cause grand jury indictment before you can make a person answer for a crime. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. There's the double jeopardy clause. Nor shall be compelled in any case to be a witness against himself, nor be deprived of liberty or property. Well, first, be a witness against himself. That's when we talk about your Fifth Amendment right not to testify against yourself. Nor be deprived of life, liberty, or property without due process. There's the due process clause. Nor shall private property be taken for public use without just compensation. So just in that one run-on sentence, you see all of these rights that we talk about. Due process, Fifth Amendment rights, grand jury rights, all of this stuff. Well, if you notice in there, the language is using the word person. And is that important that they're using that word person rather than citizen? Well, then we have to go to the 14th Amendment. The importance of the 14th Amendment, this is your quickest constitutional law class you're ever going to take, is the 14th Amendment is seen as applying the constitutional rights of the prior 10 Bill of Rights, the 10 amendments, to the states. There was, it was something that needed to be codified in the Constitution, that these were not just simply federal rights, but that they were actually states' rights as well. So here's the 14th Amendment, and I'll read this. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So now we're talking about citizens. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person. So it's different now. Now we've talked about citizens, but we're also depriving any person of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the laws. The way that has been interpreted is that if you are a person within the borders of the United States, the 14th Amendment applies all of the Bill of Rights and equal protections and due process found therein to any person. So there you go. That's why I think the United States judicial system is remarkable, because it will give these same constitutional rights that are given to citizens to any person who is being prosecuted within the borders of the United States. Great question. Sarah from Dublin, Ireland. Appreciate you. Oh, pardon me. That was Vicky from Shropshire. Sorry. Thank you, Vicky, so much for asking such a wonderful question. And Joy W. Can, thank you so much for supporting the mods with coffees. All right. And to be kind, it matters. Thank you so much for supporting the mods with coffees. I really could tell that the mods needed a little pick me up this morning. And Susie West Coast just became a member. I love this. Let's keep this rolling. This membership drive that's happening organically on its own. I appreciate you guys. All right. Where are we at here? Here we go.
Hi, Josh. Hi, Mods. Hi, CC crew. It's Patty calling from Shediac, New Brunswick, Canada. That's SHEDIAC, lobster capital of the world. Sorry, Maine. Also, warmest Atlantic Ocean waters north of the Carolinas. I have a question about Alan Jackson and the Reiner case. So everybody thinks that Alan Jackson has resigned solely because of money. I'm wondering if it's something else. Clearly, Alan Jackson has enough money to do pro bono for such a big case. Do you think it's possible that he's already on retainer for one of those high-powered celebrities that might have been at the Conan O'Brien party, and now it's a conflict of interest, and so now he's been forced to resign? Just a thought. Thanks very much. Bye, Josh.
Patty from Shediac, New Brunswick, Canada. Can I first of all say, Patty, I am so appreciative that you spelled that out. I don't know. I can't tell you guys how much time I spend every week trying to hear the place that you guys are from or figure out what you're saying and then try to figure out where that is on the map. So just even spelling it out was incredibly helpful. Thank you so much, Patty. And for the interesting trivia that goes along with the beautiful place in which you live. And it's a great question. So Patty has done some thinking and says, I don't think it's just about money. The reason why Alan stepped away and declared a conflict. It was interesting, too, that he talked about there being a conflict as to why he can't continue his representation of Reiner, Nick Reiner, accused of murdering his parents. Listen, you could be right. Is there a possibility that he's retained by somebody that was at the Conan O'Brien party and that person is on the witness list for the prosecution? Absolutely could be true. We don't know. I don't know. I know Alan. I've known him for many years. I have not talked to him about this, and I don't have any special insights. But I will tell you, I still do believe it's about money. And there's a couple of reasons for that. First of all, if it was simply about a conflict, as you point out, Patty, we would have seen another private attorney step in. If there was money there, another private attorney would be stepping in because this is such a huge case. And I think another private attorney would have happily swooped in for all of the publicity and for the paycheck to handle this case. It got assigned to the public defender's office. And you don't even qualify for the public defender's office until you reach some financial requirements, which is essentially that you're indigent. So I don't think he's got any money. I think what happened is that they went to retain Alan. They said that this is, again, just my educated guess here. They said that he's got a trust. And they said, don't worry about it. We'll work it out with the trust. Well, the trust is likely run by a trustee who is not a family member. That's usually how these things are set up, whose sole obligation is to protect the trust and the interests of the trust for the beneficiaries of the trust, which are all the children. And I bet you the trust probably had clauses specifically dealing with Nick and about his behavior, having been a drug abuser for so long. And I'm sure that trustee said, I'm not paying this check. I'm not writing a check like this to Alan Jackson to defend this guy. He can go with the public defender's office. That's how I think it worked out. It is interesting that Alan said a conflict and that Alan said a situation outside of his control. I think it's well within his control to do it for free. I just don't think that, and again, I don't know this. I don't think that he would like to dedicate the amount of resources, the time. It's going to take over that entire law firm if they took this on. And to do that for free would probably be too much of an undertaking. So That's what it looked like to me. But I love your suggestion. Here's the other thing I'll say about your suggestion too. Let's say it is true he represented somebody at that party. If there was money on the table and Alan really wanted to keep this case, he could have got a conflict waiver from that person. And I don't think that would have been a problem at all. So great question though, Patty. I don't in any way, please don't interpret that as me criticizing that it's not a fantastic question. It's a great question and a great idea. All right, let's keep it rolling here. Where are we going to next? Nope. Of course, we couldn't have this go smoothly.
This is Deanna from Madison, Wisconsin. Hey, Josh and CC fam. Hope your Sunday is going well. Like many of you, I've been following the Brendan Banfield trial closely. Since the defense has started calling their own witnesses, I've been hearing a lot of criticism of the defense attorney from other experienced attorneys saying that he really isn't doing a great job, that a more experienced or more skilled attorney would in essence, give him more of a fighting chance at acquittal. Also, that he seems disorganized and maybe a little sloppy. And of course, we heard that from the judge as well on Friday. I'm recording this on Tuesday, and the defense could certainly turn it around. We'll see what happens when court reopens. So more broadly, my question is, what conditions would need to be met for a successful ineffective assistance of counsel appeal? How does the appeal court even determine that? And secondly, if Banfield's attorney doesn't turn it around and he is convicted, do you think that there are grounds for an ineffective assistance of counsel appeal in this case? Thanks, Josh.
Deanna from Madison, Wisconsin. Let's put you on the map. I think that your assessment of the presentation of the defense case here is spot on. I think it has been sloppy. I think it has been inadequate. I think it has been shown signs of lack of preparation. And I think it probably has hurt the case. Did the guy have a fighting chance? I don't know. But I tell you what, in the hands of a very skilled defense attorney, I feel like I would have at least had a field day with Magalese. I mean, the idea that she happily, with a smile on her face and a spring in her step, was willing to kill someone, this man's wife, the mother of a 4-year-old, to take over her life, and then happily kill another man if that meant that they could somehow cover up that first murder. That to me is a very, very bad person, who then is only now willing to testify to save their own tail. And it looks like they're doing a good job of that because they're going to get this sweetheart deal while Banfield is looking at spending the rest of his life in prison. There's a lot to work with there. There's a lot of quote unquote material for a defense attorney that I don't think was taken advantage of at all. Now, in the hands of a very skilled attorney, had Alan Jackson been representing Banfield, would I expect the results to be any different than when I expect them to be next week? No. I think the guy's very guilty. I think there's a lot of evidence to support that. And, but who knows? Maybe persuade 1 or 2 jurors along the way. I don't know. Maybe make it a little bit harder. I don't know. But I don't think that they did any favors for Banfield, which always brings up the question that you brought up. IAC, does that mean he's ineffective assistance of counsel? What is the standard for that? Will they appeal based upon that? Let's answer that last question first. Yes, they will appeal based on that. They always appeal based on that. I don't care how great a job the defense does. They throw in an IAC appeal every single time. I've worked on cases as defense attorneys that have gone up on appeal, and it always irritates the heck out of me that the first argument they put in there as his appellate attorney, and that's why they usually get another attorney so they can make an IAC appeal. And lots of times that doesn't really even have to do with performance, but it has to do with second guessing. Well, you didn't call this expert, or you called that expert, but that expert wasn't all that great. And strategic decisions that were made by the defense attorney are second guessed and posed as IAC. Here's the problem. It's a very difficult standard to reach. It's beyond what you saw here in Banfield. Here's what the standard is. First of all, they asked the question, was the lawyer's performance objectively unreasonable and fell below professional standards? Well, you could say perhaps that took place here, but you could also make an argument for no. There's a lot of bad lawyers out there. Sorry that we're all used to and spoiled by seeing a lot of great lawyers on TV, but there's a lot of really bad ones. Go to any random courthouse, you can find them. And objectively, did he do it? No, he asked questions. He made objections. He cross-examined people. It wasn't like he was completely checked out. But even if you reach that standard, then you have to get to the even higher standard of prejudice, that the court would have to say that there is a reasonable probability that, but for the lawyer's errors, the outcome of the case would have been different. This means that the errors must have been significant enough to impact to undermine confidence in the original result. That is very difficult to get to. That is essentially saying Banfield is not guilty. And in the hands of any other lawyer, he would have been found not guilty. Now, we don't have a verdict yet. I'm making a lot of assumptions, but you can see how high of a standard that is. It's very difficult. It's very rarely granted, and it's only in the most extreme of cases. And I don't think that we've gotten there here. But great question, Deanna from Madison, Wisconsin. Appreciate you for asking that. All right. Let's keep it rolling here. I'm going to press all the correct buttons this time.
Hi, Josh, Tiff, Mods, and CC crew. It's Little Miss Red Velvet from Manchester. Today, I want to ask about the Tyler Robinson case. Lance Twiggs, who was his boyfriend, was under FBI protection. Then it was stopped. My question is, how much did he know? If he did know more, could he be an accessory? Or could he be a cooperating witness? Looking at his texts between him and Tyler Robinson, could there be code words in there? Could it be a code? One thing he did say to him in the text was, remember when I was engraving the bullets? Just like to know a little bit more about culpable knowledge, if you can expand on that. And also, if he is found to be knowing something, could he be an accessory? Look forward to seeing you on Sunday. Take care. Bye.
LMRV from Manchester, England. Always great to hear from you. And a great question, too. I love this one. Tyler Robinson, a case that somehow we don't seem to chat about all that much, but a case of great significance. And certainly a lot of people in the country are interested in it. Tyler Robinson accused of being the assassin who killed Charlie Kirk in front of hundreds of people in Utah. He's going to be in court on Tuesday, by the way, for a hearing dealing with trying to kick off the entire Utah State's Attorney's Office from the case. But Lance Twiggs was his roommate / romantic partner, who we've seen now this text change that's pretty remarkable between Tyler Robinson and Lance Twiggs soon after the murder took place. And he's talking about a lot of things. I mean, he's talking about having hid the gun, having committed the murder, all of this stuff. And LMRV is very perceptive, and she goes through that and goes, listen, this seems like this guy Lance knew more about what was going on, perhaps even before time, than he's letting on. And why isn't it the people of the state of Utah versus Tyler Robinson and Lance Twiggs? Why isn't he considered an accessory? Well, I think he is considered an accessory. One of the texts that Little Miss Red Velvet points to is this one right here. This is a text from Robinson to Twiggs. And he says, remember how I was engraving bullets? The effing messages are mostly a big meme. If I see notices bulge ooh-woo, I don't have any idea what that means, on Fox News, I might have a stroke. Okay. First of all, the person who wrote this obviously has intimate knowledge of what took place. The bullets were engraved. There was one that says notices bulge ooh-woo. But what about him saying, now I think it's important to point out that this is not coming from Lance, and Lance doesn't say, oh yeah, I remember you engraving bullets. But it is coming from Robinson saying, remember how I was engraving bullets. And doesn't that show a little bit of foreknowledge, a little bit of kind of knowing somebody was up to something? Well, I think if you're Lance's attorney, you could say, none of this shows that he knew that he was going to go commit murder. But I think if you're the prosecution, you go, well, what are you talking about here? What is a person sitting around engraving bullets and you don't ask a follow-up question? You're just having your morning tea. Oh, you engraving bullets? Cool. What's for breakfast? I mean, it kind of does stretch, I think, most reasonable person's assessment of this to say that Lance wasn't aware that Robinson was perhaps planning something. Did he know Charlie Kirk was the target? Did he know it was going to take place soon? Are you telling me that he did this, planned this whole thing and never had a discussion with anybody about that ahead of time? I find that hard to believe. But as much as the prosecution may feel similarly, a person can be considered a quote unquote accessory and not charged as one because they are a cooperating witness. We see this all the time with the feds. They call them unindicted co-conspirators, and they'll be in the indictment. Tyler Robinson, along with unindicted co-conspirator number 1, did plan and blah, 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 blah. And that's exactly what that means, is that those are people that they believe are co-conspirators, people who were involved in the planning, had knowledge of the crime to be committed, but they are unindicted because they're cooperating, because they are being helpful, because they are going to testify. And that's exactly what Lance is doing. I am sure Lance is lawyered up, and the prosecution has had some conversations with his attorneys about there's 2 ways we can handle this, dude. He can cooperate, he can testify, he can give us what we want, or he can go to prison along with him. And that's a fairly easy call in my view. But great question, LMRV from Manchester, England. Aren't these the best questions, guys? I didn't lead you wrong, did I? Eroy, thank you for the super chat. Says, Josh, I need to know how you feel about the first 30 seconds of BB's cross. I thought it was wild that she started essentially with, why did you exercise your Fifth Amendment right? I mean, listen, this is great. When a defendant takes the stand, I think the DA should go wild. I mean, it's no holds barred at that point. You got the person on the stand. They've waived their Fifth Amendment right. There's no more need for concern or hand-holding. It is wide open. What is the word I'm looking for? It is open season as far as I'm concerned. So yeah, I thought it was wild. I encourage it. I love to see it. I always loved when I was a prosecutor, when the defendant would take the stand. It was like, oh boy, let me sharpen my claws here. This is going to get good. A mentor of mine in the DA's office, his name is Phil Sterling, an incredible prosecutor. I watched him several times in court, and he would do something when a defendant would take the stand that I loved. Guy would testify, give his whole story on the stand, and Phil would stand up and he would sit back on that little wall that separates where the attorneys sit from where the people in the audience sit. And he'd sit back there and he'd fold his arms and he'd go, anything else? Anything else you'd like to tell us? And the defense attorneys would go bonkers. And if they didn't object, you could just see the beads of sweat forming on their forehead as they tried to bury themselves in their files and not pay attention, because that's the last thing they want asked of this guy. They just got this guy barely across the finish line with careful coaxing and coaching. And it's like, only say this and never say that. And now the first question out of the prosecutor's mouth is, anything else? This is your opportunity. This is your opportunity. We're all here listening. Is there anything else you'd like to share? And they always would go, well, yeah. I mean, I'll tell you another thing is the police got this all right. And they would just ramble and go off the rails and not tell their story properly. And it was a wonderful thing to watch. And then Phil would start in just chopping down everything they would have to say. That was a long tangent. Thank you, Eroy, for the super chat, for asking that question. Freckle Feet Kitties, thank you for the super chat. Says, for the SF map, what counts from where you call it? Yes. Oh, should we get an official ruling on this? My official ruling is that it's where you are domiciled. If you're going to ask an attorney a question, you're going to get an attorney answer. It is where you live. If you travel to the moon, and well, if you travel to the moon, we're going to put the moon on the map. But if you travel somewhere temporarily and make a call from there, I don't think that qualifies for map distinction. But if you live there, if you moved there, if you live part-time there, I think we'll make a judgment call. But great question, Freckle Feet Kitties. And thank you again to Anonymous for the mods for the coffees. Appreciate you guys. Are you juiced? I haven't seen how juiced everybody is in a while, so let us know. Gossip and Rumor, good to see you, says the DA was so excited, it's like it was her birthday. Yeah, when you're in the DA's office, there are very few things that can thrill you, but the defendant taking the stand is certainly one of them. All right, let's keep it rolling here. Get it together, Ritter. Where are you going? Wait a minute. Why do I feel like I'm going backwards? Oh, because I was going backwards. Here we go. What did we just do? Okay. All right. I'm good. Here we go. Yeah, I'm good. I'm good.
Hey, y'all. Pardon me. I'm a little nervous. I'm a first-time caller. It's Alicia K. Mayo from Humboldt, Tennessee. And happy Sunday Funday, Joshua, Tiffany, our fabulous mods, CC family, and guests. All right, Joshua, I'm thinking about Monique Tepe's alleged statements to her friends, possibly even the dentist office personnel. And I'm also thinking of other text messages and conversations or statements the other people that are no longer alive have made. And some of these things have been admitted into court as evidence and some have not. So my question is, what exactly constitutes an exception to the hearsay rule? And who determines that? Is it the judge in each case? Is it a state entity like the Supreme Court? These are questions I have. I appreciate you taking my first time call. Wish you all a happy Sunday Funday and look forward to your answer. Thanks. Bye.
First time caller, AKM from Humboldt, Tennessee. What a great question. Appreciate that. Talking about the horrible double homicide of Monique and Spencer Tepe, allegedly at the hands of Michael McKee. And this is a very interesting question. And I appreciate how thoughtful all of you guys are. Look at that beautiful picture of them, by the way. This, by the way, I think is why this man had not forgotten about her and had obsessed, is she was living her life well. She had forgotten about him. She had moved on and he had not. His life had gone into pure stagnation and obsession about her, and her living a beautiful life with a handsome guy and beautiful kids drove him nuts. But AKM's question is, what about her statements? How are they going to get all of that in? Her statements that she may have made to friends, her statements that she may have made to therapists. How does all of that come in? And who decides? Well, you're right in identifying that hearsay is the main hurdle So how are they going to get that in? Hearsay is, say it with me, an out-of-court statement offered for the truth of the matter asserted, meaning it's something said outside of court, and you're not just offering it for some other purpose, you're offering it to prove the truth of what that person is saying. So Michael is going to kill me someday. You're not offering that, but to say that Michael's going to kill her someday. Okay, so what would be some exceptions to that rule that would allow this to come in? Well, there's several. First of all, there's one called present sense impressions, which are people talking about something they're currently having recently experienced. Here's an example. Michael just called me. That would come in. Somebody saying they were next to Monique and she goes, "Oh my God, Michael just called me." That comes in because it's a present sense impression. Her saying it, having experienced it in the moment. The reason we allow these exceptions like this is that they lend more credibility to the statement being made. We don't believe somebody's just going to make up a present sense impression. Excited utterance. You've heard this one before. "Oh my God, Michael's outside my house." That is a person who is under the influence of a stressful or exciting situation and just simply almost narrating it as it happens. Existing mental or emotional state. "I'm so scared of Michael." Something like that would come in. It's talking about her current condition. "I'm sick to my stomach for what Michael's been doing to me." Things like that would come in. Also, if you listen to the conversation I had with Dr. Patrice Berry, if she's still here, we talked about whether or not her statements to a therapist would come in. Well, there's an exception about statements made to a therapist or doctor for the purposes of treatment. Those come in because we feel like you're going to tell your doctor exactly what's going on. You're going to tell your therapist exactly what's going on. What won't come in, though? Things like, "Michael said he's going to kill me." Why? Because now you're talking double hearsay. Now, you could argue that there's an exception to that, a double exception. You could say, well, his statement is a statement of an adverse party, the statement of the defendant. Therefore, that comes in as far as what he said. And then her making it falls under some other exception. There's double hearsay, her saying it and her quoting what Michael said to her. So all of these things are going to have to be litigated ahead of time, and a decision is going to be made by the judge. So it's a very, you're going to see a lot of this because I think her interactions with him and her comments about him in that 8-year period are going to become very important to establishing premeditation in this case. So you're going to see a lot of that. Great question. First time caller, AKM from Humboldt, Tennessee. All right. Water Troy, thank you so much for supporting our mobs with coffees. Appreciate that. And Grandma Law Nerd, thank you for gifting the membership. You guys are fantastic this morning. I appreciate it. Freckle Feet Kitties is back. Going on vacay to Antarctica. Appeal requested. Tell you what, you send me photos from Antarctica and we will seriously consider your appeal request. All right. Therapist, just gifted a membership. Appreciate you, therapist, All right, let's keep it rolling here. Where are we off to next? Are we off to Antarctica? No? Lord. I would say it's not my fault, but I think it's entirely my fault. All right.
From Chicago. My question is about the Brendan Banfield case. You know how he is sitting there furiously writing notes, or was anyway. He's testifying now. Superstar that he is, father of the year, husband of the year. But anyway, so Does anybody get to see what he wrote, or is that privileged information? Is that something that we can do like a FOIA request, or do we never ever get to know what he was writing? I'm very curious. Thank you. Have a great day, everybody.
Sonia from Chicago, Illinois. You know what? Given the weather nowadays, it basically is Antarctica. What is it? What is the temperature there now? Where's I always ask Kaylin what the temperature is, and I forgot to ask her this morning. Are you still in sub-zero out there? No. In the teens? No. Single digits? No. She says, leave me alone. Get to work, Ritter. It's cold. I know that a lot of you guys are dealing with that. 28 degrees, says Shy Gal in Chicago. So hope you're all staying warm. Yeah, that's what we call chilly. Let me get to your question, though. This is a great question. Shy Gal wants to know, he's been taking all these notes. How do I get my hands on these notes? I want to see what this guy's been writing down. Well, it's a great question. Some questions I'm qualified to answer. Some questions not so much. Where are we at here? This one, I had to phone a friend.
Hi, without commenting directly on the case that you asked a question about, generally any notes written by a defendant during the trial are considered attorney-client privileged, or they are considered work product. So they're not going to be disclosed to anyone. They certainly would not be subject to a FOIA request because they're not government records. Now, that being said, the privilege can be waived if you show it to a third party. For example, if he shows it to someone not part of the legal team. It could also be waived or breached if, for example, he's trying to facilitate a crime. Like he tells his lawyer, hey, this witness, we need to get rid of that witness, or we need to bribe that witness. So it really depends, but generally the answer is no. You will never see those notes. They cannot be subject to any type of request by the prosecution or the general public.
There you go. Eric Siddall knows. Eric is still a prosecutor in the DA's office. I worked with him for many years. He actually is one of the very few prosecutors in the DA's office here in LA that is called cross designated, meaning he also works for the U.S. Attorney's Office, prosecuting some of their cases. He's fantastic. He's brilliant, and he's also a very good friend of mine, and he's the person that I usually call when I am confused about something and need an answer, and he'll answer these for us as much as he has time to do. So thank you so much to Eric, and that's exactly the answer. They're never going to get their hands on it. It qualifies as either attorney work product or attorney-client privileged information, unless it's like he said, the fruit of a crime. And I'll say probably one other exception, and that is what happened here. One other exception. I didn't do that. One other exception is if Banfield took his notes with him to the stand and asked to refer to his notes at one point. Like, let's say his attorney asked him a question and he said, can I look at my notes? And the judge said, sure. A smart prosecutor would go, great, Your Honor. I'd like a copy of those myself, because you're allowed to use anything to refresh your memory, with the one rule that a copy of that has to be, or the opposing side has to be allowed to view it. So if you were to take his notes up there and refer to them, then the prosecution could get their hands on it. But otherwise, we all want a copy, says Shy Gal. Yeah, sorry. Doesn't look like it's going to happen. But great question. And thank you again to Eric for answering that for us. All right. What happened? Ann Potter, thank you so much for gifting the membership. Appreciate you, Ann Potter. Heather Cooper Smith, appreciate you for the super sticker. That's very kind of you. Seashell, I feel like it's the beginning to a tongue twister. Seashell AZ just gifted a membership, and I appreciate that. CJ in LA, good to see you. Thank you for the super chat. Says, what else are you going to get a weekly education on the law, the best channel? Oh, thank you for that, CJ. Kitty meow. Some of these names I feel like are just designed for me to sound silly. Kitty meow. Thank you for the super chat. Says, watching Brendan testify made my blood boil. He'll be the smartest person in the room when he is sitting in solitary confinement. Yes, he will. Yes, he will. And he will then not be the smartest person in the room as soon as anybody else enters that room. Are you guys having problems with the stream? I know that we had a little bit of a glitch there, but if you're having trouble, please let us know in the chat. I'm not sure what we could do about it, but I would like to know if we're having problems. All right. Can we keep it rolling here? Here we go. Oops. Now we're going to have problems. It's probably me. We could blame it on me.
Hi, Josh and CC crew. This is Lauren from Wollongong, Australia. First time caller, long time listener and watcher on YouTube. I have a question. It's about Brendan Banfield in my mind at the moment, but it could possibly apply to any defendant that decides to take the stand. I have a funny feeling that he will have already been cross-examined by the time you see this or hear this message. But what's his obligation if things get a little bit too spicy and he just wants to pull the pin? You know, all lovely with his defense lawyer at the moment. And I'm really looking forward to the cross-examination because she really gave the PI what for. So can't wait to see what she does with Brendan. But what happens if it just gets too hairy for him and he just wants to, like, can he bail? Like, what's a defendant's obligation once they start down that path to participate? That's my question. Thanks, guys. Bye.
Lauren, calling from Wollongong, Australia. This one this was one of the ones I had trouble going. What did she just say? Wollongong. WOLLONGONG, Australia. Pardon me. I apologize. I don't know how to say it properly. But first time caller, which is most important. Thank you so much for calling in. And great question. What happens if the defendant just hits the eject button and says, you know what? This is not going well. I am not doing well on cross. This is much more difficult than I thought it would be. And I'm done. I don't want to ask this anymore. I would like to take my seat. Please bring me back to my cell. Well, what can happen strictly from a, legal perspective is that the prosecution can ask to, first of all, the judge will try to compel the person to stay, and the judge might threaten contempt. Now, this guy's been sitting in jail. Threatening him with more jails is not going to work. He's likely looking to be in prison for the rest of his life. So I doubt any kind of threat of contempt will work. And judges are reticent to do that when it comes to a defendant anyways, because they don't, again, want to create some sort of appealable issue. But the prosecution could ask to strike his testimony. I want all of his direct examination stricken because of my inability to properly cross-examine them. I want that completely stricken. And I want the jury instructed that they could not only should disregard everything he said, but that his refusal to answer questions can be considered by them as evidence of his consciousness of guilt and blah, 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 blah. Tell you what I would do, though. I'd have a field day with it. I would, and I'm sure the judge would give you plenty of latitude to do this. Oh, you got nothing to say now? You had a lot to say yesterday. You don't have any answers for us now, sir? What happened to wanting to share your story, sir? What happened to wanting to right the wrongs against you, sir, with this jury? You've got nothing. You've got no answers to these are very simple questions. You got no answers to these incredibly simple questions, and just on and on. Isn't it true, sir, that you're refusing to answer my questions because you are in fact guilty of murdering your wife? And just, talk about, somebody asked earlier, going wild. That's where you have some fun. And I think a judge would let you do it. I think a judge would let you do it to a point, just to drive that point home to the jurors. And I would probably do it until I saw some tears. But that's the kind of stuff you live for. It's not like you're all that worried that, oh, somehow this is going to backfire on you because the guy doesn't want to testify anymore. This is where you just dig in and have some fun. Great question, Lauren from Wallalalong, Australia. Appreciate you calling in, and appreciate you being a first-time caller. Please call back again. All right. Where are we going to next?
Hey, Josh and CC crew. This is Kathy. I have a quick question. In the Banfield trial, the judge mentioned that the jurors' names are sealed for a year. Does that mean we have to wait a year to hear from them? So, anyway, hi everyone. Hope you're having a great Sunday fun day. Talk soon. Bye.
Kathy from New York. Let's put you on the map. Hold on. Let's put New York on the map. Kathy, so great to hear from you. 750 is the goal, says Eroy. I don't know where we're at right now, so I hope we reach that. Always appreciate the challenges coming from Eroy. Brendan Banfield, the judge has, or somehow there's been an order, or it's the standard in Virginia where he's being prosecuted, that the jurors' names are sealed for a year. Is that the first time we're going to hear from these people? The answer is no. If they want to, they could come out right after the verdict. They could start putting up TikToks if they wanted to. We've seen that before in the past. They can talk to whoever they want. This is for their protection, their anonymity. If they don't want to be anonymous, they don't have to be. And it's not that they are compelled to speak after a year. They could still refuse to talk if they don't want to, but their names will be released for public records requests after a year, which I've got to tell you is a little surprising to me. I'm used to, here in California, they're never released. They can remain anonymous for the end of time if they want to. So it's interesting that in Virginia, they actually put a time limit on it, of how long they're going to keep their names under wrap. But, if you're willing to wait around for a year, then you'll find out who they are, and then reporters can start reaching out to them, which they'll probably do. If he's convicted, they'll do some expose on the 1-year anniversary and interview the jurors if they're able to. So, Kathy, great question. Thank you so much for asking. All right. Let's keep it rolling here. We've got a lot of the world to cover.
Hello, Joshua, CC crew, CC fans and chats. This is Beth from Denmark. In my own voice, I will say thank you for taking my digital question last Sunday. To use the digital way is a big help for me because I'm going blind. So it takes me a long time to put a question together, and I have a hard time seeing my notes. But again, I do so understand, Josh, that if all our questions was digital voices and you never heard a human voice, it would go very boring. So this is my little message this Sunday, and I would wish everybody a happy Sunday fun day. Bye from Denmark. Bye bye.
Beth, this is so sweet and kind of you. I appreciate this message so much. Beth calling from Denmark. We're going to put you on the back. Beth called last week and left us a message that was AI generated. When I say AI, that's maybe not the right word, but it was voice to text or text to voice, so that she could participate. And I thought that was fantastic. And listen, it's obvious that English is not Beth's first language, but she speaks it very well. English is my only language, and I don't speak it all that well. So I appreciate and applaud anybody to go outside of their comfort zone and leave a message. And if that means that you have to do text to voice, thank you, Kaylin, to get that accomplished. I appreciate it. I thought that was a really touching thing, and I appreciate you calling in to explain that to all of us. And thank you again. All right. Okay, here we go. You guys, let's get to 66.6 and 750 likes on this stream to get gifted memberships from Eroy, and we'll throw in some too. Where are we at? Are we close to that goal? I love these goals. It's like, I feel like we're part of those old school telethons. Do you remember those? Well, we're very close to 66.6. We've got maybe 3 more to go. And I can't tell on my thing how many more likes we got to get. Do you guys remember those telethons? Can't believe that was a thing. They would actually have the bank of telephone. Kaylin, do you remember these? Kaylin has no idea what I'm talking about. They would have like in studio banks of telephones, and people would be answering them, and you could call in live. They still do telethons. Well, tell Kaylin where to watch it. And you would like call in and, oh, this person just donated $100. Like PBS would do it. All of the public stations would do it. PBS after Lawrence Welk. There you go. See? Kaylin doesn't watch TV. She just works on the next presentation for Courtroom Confidential. All right. Where are we going? What did I do here? Oh, wait a minute. Now I see what I did.
Hi, Josh. This is Taylor from Bluffton, South Carolina, and I am calling in regards to the Aaron Spencer case. I know that he got a new judge, which I'm super happy about, but I was wondering what happens next. Do you think that they're still going to push forward with the trial? Like this week or next week? I haven't seen if they changed the trial date yet, or what typically happens. Does it usually get pushed back? Yeah, so been following you and subscribed for a long time and love your shows. Thanks. Bye.
Taylor, thank you so much for the kind words, calling from Bluffton, South Carolina. What is going on with Aaron Spencer? This case is fascinating to me, but I think it's actually taken some turns in the right direction. There he is. Kaylin knows if she doesn't put up the picture with him and his turkeys, I'm going to have a bad day. So just to catch everybody up on this one really quickly, Aaron Spencer, the gentleman right there, lives in Arkansas. He is a turkey farmer. He's accused of killing a man by the name of Michael Fossler, who's 67 years old. This man had previously assaulted S.A., Spencer's daughter, who's 14 years old. He was charged with 43 counts of S.A. on a minor, along with possession of child pornography, internet stalking, and no idea what's going on there in Arkansas. He was only given $5,000 bail, and he got out. So during that period of time where that trial, the charges for all of the acts against a minor were pending, he then kidnaps Spencer's daughter, October 8th, 2024, in the middle of the night. And Spencer finds his vehicle in the middle of the night, hunts him down, makes him pull over. One thing leads to another. He ends up shooting the man 15 times. He unloads his gun on him, shoots him. This case had a lot of controversy already surrounding it because the original judge, Judge Barbara Elmore, had put it under this severe gag order. And finally, the Supreme Court there in Arkansas said, you got to lift that gag order. Then the defense says, Judge, we feel that you're too, and the reasons for this have not been made entirely clear, but it's essentially they objected to the judge for being biased, embroiled, whatever it is. Judge, you're not the right judge for this. We're asking you to recuse yourself. That Judge Elmore refused to recuse herself. The defense appealed it up to the Supreme Court of Arkansas, which recently said, yeah, you're right. This judge needs to go. The judge needs to go. Prior gag orders are lifted that hadn't already been lifted, and restrictions on videotaping inside the courtroom and the amount of people who are allowed to be in court all lifted. Great on them. They've said, you know what? This case, the best, what do they say? The best, what is it? The best sanitizer is sunshine, whatever. And in this case, they realize the best way to handle and try to preserve some confidence in the judicial system is to open this case up. We're going to remove the judge. We're going to open it up to the public. We're going to allow them to assess whether or not justice is being done here. And I applaud them for that. It's now been assigned to a judge named Ralph Wilson. He's going to preside over it. But because of that, there's a delay and a new trial date has not been set. And in the meantime, he's running for sheriff. So there you go. A case we're following very closely. We will keep you updated as much as we can. And if this ends up going to trial, which I actually don't think it should, this should settle. They should give the guy some sort of probation. Listen, I understand they can't ignore that a person got shot, but give the guy some sort of probation and move on and let him move on with his life. If it does go to trial, though, it sounds like maybe now there will be cameras and maybe we can stream it for all of you. So stay tuned. But thank you, Taylor from Bluffton, South Carolina. Debbie W. says Elmore was the judge that handled Fossler's case. Oh, interesting. I mean, I imagine, there's not a ton of judges in that local community there, but that's interesting as well. I understand, too, Tiffany was telling me that he's very involved with advocacy on the behalf of children who've suffered abuse. So it sounds like he's the perfect judge for this, and maybe we'll get some justice. Because I think right now it's an injustice that they haven't, set aside a special day in his honor and handed him the keys to the city. All right, let's keep it rolling here.
Hi, y'all. This is Court Dog Daniel from New Britain, Connecticut. Josh, I suspect you're very humble, so you probably won't want this unfiltered compliment aired. So, Tiff, I'm trusting you to make sure this one gets on. Attorney Ritter, I put you in the same league as my favorite attorneys, Cappleman and Silverman of Adelson and Cementilli fame, because of how clearly you break down complex legal issues on this show. So before my question, I'm not asking you to drop names unless you want to, but could you give us a quick thought on the attorneys you enjoy watching and what stands out about their work? Also, my brief question is about the Brendan Banfield trial. If he were convicted but later won a new trial on appeal and the au pair has already returned to Brazil, would she be subject to extradition for the new trial, and how realistic is that? Thanks as always. Juiced!
CDD from New Britain, Connecticut. One of my dudes. First of all, thank you for the very kind words. I am flattered, and I do not think I should be considered in the same category as those incredible prosecutors, but I appreciate you saying that. 46 to go, says E. Roy. Keep it up, everybody. We'll get there. Oh, congrats on 66.6. So I think we're halfway to our goal, at least. There we go. Thank you, guys. Always nice to reach a milestone while we're on a live stream here. Let me answer your second question first, though, Daniel. Brendan Banfield, this is a great question, too. So let's say he's convicted. Magalese is sentenced. She serves her sentence and they deport her. Then, for whatever reason, maybe IAC, who knows, Banfield, they decide he needs a new trial. What do they do about her? Can they get her back to court? Can they extradite her back to the U.S. so that she can testify again? The answer is no. She will have satisfied her part of the agreement. She testified and she got sentenced. And then she served her sentence and she got deported. So the U.S. doesn't have jurisdiction over her, not in the sense of like geography, but in the sense of even trying to say that she hasn't fulfilled her obligations of the plea deal. So they can't get her back. So what do? Are they going to have to put on a new trial without her? Well, if she doesn't agree to come back, she would qualify at that point as an unavailable witness. When you've got an unavailable witness, what are you allowed to do that you're not normally allowed to do? You're allowed to put on their prior sworn testimony. Well, isn't it convenient that her prior sworn testimony happens to have been at trial and happens to have been videotaped? That's all they do. They just play the trial from the first time around, which has happened in cases before. In the Phil Spector prosecution is the first thing that comes to my mind. He was prosecuted. They had a hung jury. They had to prosecute him again. And one of the pivotal witnesses actually died in between. So they just played her testimony from the first trial. It was recorded by Court TV. They just pressed play for that testimony. And the jurors got to see that prior testimony. Now, hey, wait a minute. I didn't get to cross-examine this witness. Well, the way that the law views that is that that person was subject to cross-examination under the same kind of interests as the second time around, and therefore they'll allow that testimony in. Great question, Court Dog Daniel. Now, to your question about who do you enjoy watching? A couple of attorneys came to mind immediately that I am big fans of. One of them is no longer a prosecutor, but is now a judge, and the other one is still a prosecutor in the DA's office. The first is this guy right here. His name is David Walgren. I was a law clerk for his a long time ago. One of the best lawyers I've ever seen in my life. Just phenomenal, smooth, relatable, smart, unflappable, really, really, really good trial attorney. He handled, if you guys remember, the prosecution of Dr. Conrad Murray for the murder of Michael Jackson. This was the doctor that overdosed him on, what was it, propofol or fentanyl or something. I mean, horrible, horrible stuff he had pumped into Michael Jackson, causing his death. And it was kind of seen as a difficult prosecution. Like, how are you going to prosecute a doctor who's giving medication to a person who's also asking for it? Well, they put it in the hands of Dave Walgren, and he did a remarkable job and got a conviction out of that case. He's handled many other cases. I worked with him on a death penalty case. Very, very good. Just a lot of what I learned very early on as a young prosecutor, I learned from him. And another guy who was in that same major crimes unit, who you may recognize, but very, very different stylistically, is John Lewin. Also an incredible prosecutor and an incredible lawyer. But these guys couldn't be more different. I mean, just even in the photographs there, Walgren is this kind of sharp, put together, well-tailored suit. And then you got Lewin, who, looks like he left that jacket on his bedroom floor overnight. And he just kind of gets into court. And I'd say this to Lewin's face. We're good friends. He's not, I'm not throwing him under the bus here, but he is just entirely different stylistically, but also remarkably effective. And part of what he does is this kind of aw shucks thing in court. And it's not fake. It's not disingenuous that he's putting it on. It's just kind of his personality. But jurors love him. They love hearing from him, and he's handled some of the more difficult cases in the office, including Robert Durst. So he, that was a case that guy got away with a couple of murders before he landed on John Lewin's desk, and he was able to prosecute him. So check those guys out. I'm big fans of both of them. Eroy. Oh my goodness. I'm guessing we met the challenge here. Eroy, thank you so much. That is fantastic. You got to see it. You can't see, but Tiffany's doing one of these right now. That is very, very kind of you, very generous. We really appreciate the support to the entire community. And to everybody receiving one of those. Thanks to Eroy for the love, for passing it on, and I hope everybody enjoys those memberships. That's fun stuff. I appreciate it. Okay, I'm cut off from these challenges until next month. Sounds good. Appreciate it, Eroy. Very, very sweet of you. Hippie Mimi, thank you for the super chat. Jumping on board. And Heather Coopersmith, thank you for the super sticker. You guys are all fantastic. I love it. Court Dog Daniel, there he is, gifted a membership. Thank you, my friend. Appreciate that. Wow, what a great day. Where was I? Oh yeah, Dave Walgren, John Lewin. Check him out. Dave's now a judge, really good judge. John's still in the office, still hunting down guys from he specializes in cold cases. So he's the guy that if you feel like you got away with it and all of a sudden he shows up at your door, you're in big trouble. So thank you for that, Court Dog Daniel, and thank you for that again, Eroy. That was very, very kind. Oh, there we go. Five coming from the CC crew over here, CC headquarters. God, we're gonna have a bunch of new members. You better get ready, Tiffany. You gotta do a lot of live streams with all these folks. All right, where are we at? Quit gabbing, Ritter, and just get to the next call here. What did I do? Why am I confused? Okay, here we go.
In Courtroom Confidential listeners, this is Dawn in Fairfax, Virginia, where the au pair Brendan Banfield trial is being held. If the jury would come back hung, what does that do to Juliana's deal if the Commonwealth would want to retry the case? Because right now it looks like Juliana gets time served for doing her part in this trial. Would love to hear what happens if you know. Thank you and happy Sunday Fun Day.
Dawn from Fairfax, Virginia. This is a great follow-up to Daniel's question about, what if there's a hung jury, or what if there's a new trial and she's already out of the country? Now we go, well, what if there's a hung jury? What happens to her deal? I guarantee you the last person who wants a mistrial on this case is Juliana, because that is not considered having satisfied her deal. Her deal, I'm sure, includes to the resolution of the case, to the verdict or resolution, if he pleads out or whatever it is. Well, if there's a hung jury, that's a mistrial. It's like the trial never happened. So double jeopardy doesn't attach, and also her obligations are not done. What are they going to say to her? They're going to say, sit tight, Juliana. We got to do this again. And oh, by the way, too bad, so sad. We're not doing it for another 6 months to a year. God forbid this actually happens, but that could easily happen if they declare a mistrial, that they kick it on down the road for another 6 months to have another attorney prepare for the trial or something. And she just sit in jail because she's still looking to get that deal. And by the way, don't cry any tears for her. I mean, I don't care if she sits in there for a couple more years. It's still far better than spending the rest of her life in prison, which I think she should have gotten. I really think she should have gotten that. I do not think giving her, if the deal is truly a time served deal, I believe she's looking at as much as 10 years. That is even low in my view. I think she should have been looking at some sort of second-degree murder here and a long time in prison. And maybe she wouldn't go for it. Maybe she wouldn't cooperate. But you telling me they couldn't patchwork this case together without her? I realize she made it a lot stronger, but was it worth giving her what they gave her? Again, I'm not trying to, Monday morning quarterback all of the prosecutors here, but I'm just offended by how culpable I think she is, and that there's the possibility that she could be sitting on a beach in Brazil in a year's time. Does not sit well with me. But Dawn, thank you so much for the question, calling from Fairfax, Virginia. Oh my Lord. Get out the hankies. It's that time. We're down to the final three, guys. But we've had a good time. Chris Robinson, thank you for the super sticker. Appreciate you. CJ in LA, thank you for gifting the membership. You're so kind. Court Dog Daniel, I'm on quite a few true crime channels, and this is by far the best one, folks. You guys are fantastic. Have we covered a lot of territory, not only geographically, but also case-wise? We've talked about Banfield quite a bit. We've talked about the Tepe murders. We talked about Tyler Robinson. Talked about we had some constitutional law thrown in there. Telling you, I hope that you guys understood all of that, because that was like probably the first several weeks of Con Law 1 wrapped into about a 5-minute question. Eroy says, can the judge deny the plea of time served? I don't think she has pled to a particular amount of time. I think what it is the deal is they will make a recommendation for her, but she's got a certain exposure and it's up to the judge. So it could be that the judge says, I don't think time served is at all appropriate, and I'm going to max you out for 10 years. But I think that's the problem, is what they're willing to let her plead to has a max time limit on it. And that time limit is not nearly what it should be, in my humble opinion. Loves my dogs. Just became a member, everybody. I love it. I love your dogs too. All right. Here we go. Final three. Let's see how we round it out here.
Hi, Josh and Courtroom Confidential crew. This is Intuitive Karen. Longtime listener, first time caller. I am from Fairless Hills, Pennsylvania. I have a question about the trial itself. Most people choose a jury trial, but there's also the option of a bench trial. When would that be most useful? It seems like not too many people pick a bench trial, but it's there for a reason, I'm assuming. Could you explain that to me? Thanks a lot. Bye-bye.
I can. Karen from Fearless Hills, Pennsylvania. Let's put you on the map. I love that name, by the way. Where do you live? Fearless Hills. First time caller too. Thank you so much for working up the courage to call in. Hope to hear from you again. And it's a great question. When would you ever choose to have a trial just in front of the judge and not in front of a jury? It is extremely rare. It's also something that both sides have to agree to. I happen to, as a prosecutor, have done a bench trial before. I'll tell you the reason we did that in that case is because it was one of those situations where the defendant simply would not take a plea deal, felt entitled to their trial, but the defense attorney could convince them to do a bench trial, which just saved a lot of time. It meant we didn't have to go through all of the jury selection and deal with the jurors, and all of the issues and trouble and coordination that comes along with that. We just started the trial right in front of the judge. Are we ready? You ready? I'm ready. Let's go. Opening statements, put on our witnesses. I think we handled that thing in a day. It was like a day or maybe we came back for closing arguments the next day. So it was super, super quick. That's one reason, but usually not the reason that you see it happen. Usually it's because of a rare situation where you have the facts of the case are incredibly emotionally volatile, something so horrific factually, but legally, the defense might have a very specific legal argument they want to make. So, you know, a case involving the death of children, but there's some sort of legal loophole that they want to argue. And the defense feels, I'm not going to get anywhere with the jury on this. The jury's going to hear these facts and they're just going to hate me and not care anything about what the law says. So maybe I've got a better chance with a judge who has heard and seen it all and will hopefully follow the law and not his or her own emotions. An example recently of that was the Laken Riley murder trial. She was murdered by a man by the name of Jose Ibarra. It was one of those cases that affected a lot of people, highly, highly emotional. She's just out for a jog one day. He kidnaps her, drags her into the woods, assaults her, and kills her. It was horrific, horrific factually. And I think that though it didn't have that element of some sort of weird legal kind of nuanced argument, I think that his attorneys just felt, listen, a jury is just going to want to skewer this guy from day one. We need to, if we have any chance, go in front of a judge. And interestingly enough, now they're back in front of that same judge saying, Your Honor, you didn't make the trial very fair. Therefore, we want a new trial. I'm not going to go anywhere, but that's why it's recently in the news. But this is kind of the situation that you might see it. It's not that common. And a lot of the reasons too is sometimes prosecutors go, I see what you're trying to do, and no way, we're putting this in front of a jury. So great question. Karen from Fearless Hills, Pennsylvania. Appreciate you calling in for the first time. All right. Heather Cooper Smith, thank you for gifting the membership. This is so awesome. I can't even tell you guys what a fantastic mood you are going to put Tiffany in for the rest of the day. She loves when our membership numbers grow. She cares very deeply. So does Kaylin and so does myself. But Tiffany, this is like her baby, is the membership. And she cares so deeply about growing our membership and adding more benefit. And so you guys are making her very happy. Happy wife, happy life. So it's making me happy too. All right. Where are we going to next here? No. Somebody move the buttons around or something.
Hi, Josh. This is Paula from Arlington, Texas. Longtime court watcher. Watched Court TV back in the day when it was Ricky Kleeman and Fred Graham and a much younger Vinnie Politan. And I loved everything that I learned. And your show really reminds me of those early days of Court TV. And I've just really enjoyed listening to your show since I found you. Easy question for you. Like I say, longtime court watcher. And the other day it just dawned on me that this is a courtroom procedure. Like when the lawyers want to approach a witness, they have to ask the judge, may I approach? Or when anybody does a lot of things, they have to ask the judge permission to do that. And it just dawned on me that I've been seeing this for years and didn't really think anything of it, but I really never knew why. And I'm just wondering if you could answer that question. I know you can do it off the top of your head, no research required. So last thing I'll say is you have the best hair in true crime. Thanks. Bye.
Paula from Arlington, Texas. Thank you for that. Now you put me in a good mood. Very kind of you. Great question too. I put this in the category of stuff that I just figure everybody knows and never would think to answer this question if it hadn't been asked of me. But yeah, why did the attorney say, may I approach? Even when they're approaching the judge, may I approach? I've seen it, it really, a lot of it depends on the judge. I've seen situations where the judge doesn't even want you to pick up physical items of evidence without asking permission. really what it all comes down to is, there's a little bit of kind of tradition and respect for the court, but it comes down to security. A lot of it. You've got deputies in the courtroom who are armed. They're in charge of kind of protecting the court. And it's just kind of this idea of you don't just start walking willy-nilly around the courtroom like you own the place. If you're going to approach a witness, you ask the judge, Your Honor, can I approach to show them this piece of paper, rather than walking up there and maybe making the deputy nervous or making the witness nervous. It just kind of gives everybody a heads up. Some judges will say, you have permission. Whenever you want to approach, go ahead and approach. But it's so kind of built into you that many times you'll ask anyways. One thing you do not do, I don't care how casual you are in court, you do not enter what's called the well. If you think about a courtroom, you've got like the witness stand, you've got the judge's bench. They're sitting up high in their black robe, looking down on everybody. You've got the court reporter in front of the witness stand. On the other side, you've got you've got the juror sitting next to the witness, right? And then on the other side, it's usually just kind of blank space where they have the defendant enter the courtroom through lockup in the back or something, right? And then you've got where the attorneys sit. And in between, where the attorneys sit, where the judge's bench is, and where everything kind of situated is this big blank area called the well. If you enter that area without asking the judge, or if you try to approach the judge through the well without permission, bad news. I've seen judges, that's the one thing that'll kind of set them off, is that area is seen as just, I think it's a security thing. I think it's just kind of a courtroom etiquette thing. You do not go in the well without asking permission. So if you got to hand a document to the judge and you got to enter the well, or you want to approach the bench to discuss something, make sure you get permission before you do that. All right. It's our last question of the day, everybody. Wait a minute. Let me thank Dr. Vonda K. Thank you so much for the gifted membership. Very kind of you. All right. Oh, Cheryl just gifted a membership. Cheryl R., you're fantastic. Kathy Mama Bear gifted memberships. You guys are all awesome. This is great. Very happy, Tiffany. Best hair in true crime. Don't rearrange the letters. BHITC. Oh. Best hair in true crime. Don't rearrange the letters. That's true. All right. Where are we going to next? Well, I've got a special treat for you guys on where we're going to next. Just listen.
Hi, this is Carol in Kenya, in Ongata Rongai, Kenya, just outside Nairobi. I'm a longtime listener. I'm not very active on the chat, though I've said hi a couple of times. I just guess I don't know how to do the chat thing. And most of the time it's in the background and I'm doing something else while I'm listening. So I don't really have time for the chat. But I did have a question. I've been watching this Brendan Banfield trial, and I'm just kind of surprised to see him sitting all by himself with this one lonely little lawyer that's supposed to be doing his work. And I just don't understand why he's all by himself. Why is there not like a table full of lawyers? I mean, even Lori Vallow, who was pro se, even she had a table full of people there. Why are there not other people sitting at the table with them? So anyway, that's my question. Thanks a lot. I enjoy your show. Bye.
Carol, this is so cool. Carol calling from Ongata Rongai, Kenya. Yeah, zoom out there. Carol is the president of the Kenyan Courtroom Confidential fan club by her lonesome way out there in Kenya. I love it. Look at that. Look at Is that somebody in? Oh yeah, we have a caller from Egypt, Alexandria. But between Egypt and South Africa, Carol is holding down the fort. Thank you so much. I love that. That was such a treat. And a great question too. Why doesn't Banfield have a team of lawyers sitting next to him? Why is he just sadly sitting there with just his lawyer? And you bring up Lori Vallow. I think that's a good example of, she had a team of lawyers. Well, Lori Vallow had a team of lawyers that were being paid for by the taxpayer. She didn't pay for one of them. In fact, all of those lawyers were just standby counsel to help her with her ridiculous circus of a trial she wanted to put on. But every single one of those were being paid by the taxpayer. The reason poor little Brandon doesn't have a team is he can't afford it. All he can afford is the hot shot that he's got sitting next to him, and probably not a team of people to go along with him. So when you see, Karen Reed's and the others of the world with their team of lawyers there, they're paying for all of those people. Some of them might be doing it out of the kindness of their heart because they want to be involved in the case, and some of them might be doing it on the cheap. But that's, nobody felt so inclined for poor Brandon here. And so all he had was his own lawyer. But I don't think we're all going to cry ourselves to sleep about that one. But again, thank you, Carol, from Angada Rongai, Kenya. I think we're still holding out on Antarctica. Isn't that the last one? I think that's the last continent we have not gotten to yet. And then after that, are you going to put it? There we go. Look at that, guys. Isn't that cool? Have we done South America? No, nobody in South America. I gotta start polishing up on my Espanol. Apparently that's the problem. I love this though. This is so fantastic. After we hit every continent, Russia. Have we got Russia? I think we need to get into Russia somehow too. After we get, I don't even know if maybe this is some of the places where YouTube is banned. I don't know. After we hit every continent, then we have to go extraterrestrial. So we're never going to stop. Great job, everybody. Appreciate it. You've all been fantastic. Heather Cooper Smith, thank you for the super sticker. All right, don't go anywhere. Don't press any buttons. I'm watching. I just have some announcements for you. First of all, let me tell you about our website, thecourtroomconfidential.com. If you guys enjoyed the questions this week, but you think he didn't answer a question I'm curious about, and I want to ask a question, the best way, and in fact, the only way you can do that is go to thecourtroomconfidential.com and click on leave us a message. And then, like I said, if it's true crime related, case related, leave us a question, we'll answer it. And I do my best. I really appreciate you guys for being patient. If you didn't get your question answered this week, if you didn't, don't feel bad. Ask it again next week, or ask another one next week, and I'll try to get to it. Memberships. A lot of you got memberships. Thank you again, Eroy. That is so touching and so kind and so generous and supportive of you. Really, really appreciate it. But if you're like, hey, I didn't get one of those, and you still want to be part of our membership, then go to thecourtroomconfidential.com and click on become a member, and you can join the crew. We've got all sorts of different membership levels with all sorts of different bells and whistles and perks involved. And if you are curious as to how to get your hands on one of these fantastic, flashy, comfortable, well put together Courtroom Confidential t-shirts, we've got this color plus dozens of others available up on the shop. So click on the shop at thecourtroomconfidential.com. Therapist, says this color is called Glitter and Gavel. I like that. That's cute. What else do we got? Come on, Tiff, you're slowing the draw here. Here we go. Therapist, says Teeny Tiara Tyrant Defense Team. Okay. And Alicia K. Mayo says, compliments my blue eyes. Finally, Therapist, says, lilac liar who lies. A lilac liar who lies. If you want this shirt or the other colors we got available, it's at the shop. Plus, we've got quarter zips and hoodies and pajama pants and mugs and a bunch of other stuff. Journals, fun sweaters, t-shirt. We got you covered. We got everything. Beanies for the cold weather. And the Connolly Show, listen to me and just became a member. Do what the Connolly Show just did and become a member at thecourtroomconfidential.com. All right, what did you miss this week? You missed on Friday, we had our weekly roundup. That's up on the channel now. We talked about Banfield and Mangione and Corey Richins and Michael McKee and all of the cases you've been following. Please check it out. That's up on our channel right now. We sum up the entire week. Also, on Fox Nation, I co-host a show called The Weekly Rap Sheet along with Paul Morrow and Donna Rotuno. We talked about Aaron Spencer and Ryan Wedding and a gentleman from, I use that term loosely, from Southern California here called Gordon Gudarzi. Really fun episode. Please check it out at Fox Nation. It's up now. And on Dr. Patrice Berry's channel, I don't know if she's still here, but we're all big fans of her. I was on her channel called Psychologist Reacts talking about the Michael McKee case. So please check that out. We did that yesterday. We did have so much fun yesterday. Thank you for having me. What do you have to look forward to this week? Well, we're on verdict watch for Banfield. So on Courtroom Confidential live trials, what is the plan? Are we just going to stream the courtroom waiting for an announcement, or are we going to go live when we hear something? We're going to stream the courtroom. Okay, so check it out. Good background music, I'm sure, while you, I don't know, do your chores, work from your laptop. You're not going to miss a thing at Courtroom Confidential live trials. We're on verdict watch for Banfield. Then on Monday, we have our Monday night special. It's the True Crime Docket. Our special guest will be Scott from Recovery Addict, who has followed every minute of the Banfield trial. So I want to hear his thoughts. We might have a verdict by that evening. And even if we don't, he can catch us up onto anything that we may have missed. So bring your questions for Scott. That'll be live tomorrow at 5 p.m. Pacific, 8 p.m. Eastern. And then on Wednesday, TBD. We're working on a guest, but it's going to be a good one. That will be back at live at 5 p.m. Pacific, 8 p.m. Eastern. That is the week coming up. Eroy says, you think we're streaming the courtroom? We're really talking about food in the chat. That's what I figured. I figured something good's going on in the chat. Finally, in May, there's a special event coming up that I would love for as many of you to attend as you possibly can. It is called CrimeCon. It's going to be in Vegas this year, and it's going to be a lot of fun. We are going to have a booth. We're going to be doing some speaking stuff. We're going to put on a meetup. We're going to take pictures with all of you. We're going to have merch available there. It's going to be a fun time. We would love to see as many of you as possible. And if you need one more reason to go, if Vegas and Courtroom Confidential was not enough, Josh, can you get us a discount to subscribe? Yes, hold on. First, I'm going to give you a discount to CrimeCon. So if you enter the word courtroom, all in caps, all one word, at checkout, you'll get 10% off. To Christina Gibson, yes, I'm working on that for Fox Nation. It's in the works. And as soon as I get it, you guys will have it. To get you a discount to sign up for that streaming service. So that's all the announcements I have for you. You guys are all fantastic. Thank you so much, everybody, for the generosity today, all the super chats, all the gifted memberships. Again, big thanks to Eroy. That was what a fantastic gift for everybody. Big thanks to Eric Siddall, my buddy, for answering that question. And a very special shout out and thank you to our wonderful mods. Oh, thank you, Amy Joy, for supporting the mods with coffees. To Afton, Sonia, Kathy, and therapists, you guys are fantastic for all the work you do. Best in the business. Kaylin, what am I going to say to Kaylin that I haven't already said? It was a fantastic show, as always, for all the hard work, all the stuff that Kaylin does behind the scenes and how hard she works at this before we even press play is incredible. So thank you, Kaylin. And Tiffany, you are the best thing that has ever happened to me. All right, you guys have a great rest of your Sunday, and we'll see you all soon. Take care. Bye-bye.